Hello, my name is Isabella Fernandes and I am an associate in the technology practice at Matos Filho. We are here today to discuss the recent publication of the International Data Transfer Regulation by the Brazilian Data Protection Authority. These regulations aims at regulating the international data transfer in two different occasions. When the transfer is carried out to countries that provide an adequate level of protection recognized by the Brazilian DPA, or when the controller demonstrates compliance with the LGPD through contractual clauses or binding corporate rules. In today's episode of Único, our partners in the technology practice at Matos Filho, Fábio Kujalski, Luiz de Sessa, Paulo Brancher, and Thiago Sombra, will briefly discuss the key points of this regulation. Before addressing the transfer mechanisms that were actually regulated, the new regulation establishes a distinction between international data transfer and international data collection, which is aligned with international standards and was not originally provided by the Brazilian data protection law. Luis, I believe this have a practical impact on the obligations applicable to data processing agents. Can you comment on the difference between these two definitions and why is this distinction so relevant?
Thank you for the question, Isabella. Happy to do that. Well, the much anticipated international data transfer regulation has certainly introduced important rules and provision for processing agents operating in Brazil. One of the key aspects is the clear definition between what counts as an international data transfer and what qualifies as international data collection in Brazil. Now, let's get straight to the point and break down what each concept means. International data transfer refers to the process of transferring personal data from an exporting agent to an importing agent located in another country. International data collection, in turn, happens when personal data is collected directly from the data subject by an agent located abroad. And why is this distinction so important? Well, the regulation determines that an international data transfer can only happen when relying on A, one of the legal bases outlined in the LGPD, and B, one of the transfer mechanisms allowed by the regulation to support an international data transfer, such as adequacy decisions, standard contractual clauses, binding corporate rules, or specific contractual clauses. If a specific data processing activity does not fall under the definition of what an international data transfer is, but is instead considered international data collection, the processing agent will still be subject to the LGPD if it fits within its territorial scope, but it won't be subject to the same rules for international transfers, meaning it won't require one of the transfer mechanisms I just mentioned. Finally, it is worth noting that the authority's understanding aligns with international standards, such as the guidelines published by the European Data Protection Board in 2021. And that's why I believe this has been welcome news to most processing agents that fall into this type of activity in Brazil.
Thank you, Luis. These definitions and these discussions are very important for all data processing agents so they can assess the obligations that they are subject to under the Brazilian data protection law and under this new regulation. And now, Thiago, one of the mechanisms that the LGPD establishes is the transferring based on an adequacy decision. This is aligned with the GDPR, and this is a type of mechanisms that will not require other specific authorizations or other contractual mechanisms. Can you briefly comment on what is an adequacy decision and how is the Brazilian Data Protection Authority expected to issue them?
Yes, thanks, Isabella. Well, this is a very interesting topic. Adequacy decision will allow Brazil or other countries to transfer data to Brazil in a massive perspective. This is the broad way to transfer data or massive sort of data for one country to the other or for an international body to the other. So taking a step back, here adequacy decisions represent a recognition by the Brazilian DPA that a country or international bodies offer a level of data protection equivalent to the Brazilian legislation. This is very important to highlight. This recognition will allows for data to be transferred without the need for additional protections or specific authorizations, which will allow most of the companies to have low costs, transfer a massive sort of data to one jurisdiction to the other. It can enable stable and predictable scenario for sectors that depend on data and for international trade. Regarding the criteria for granting an adequacy decision, it's important to mention that the criteria for evaluation, such as a general and sector-specific norms of the destination country or international body, the nature of the data, compliance with data protection principles, and rights of data subjects, this regulation has brought some transparency requirements, establishing that the following will also be considered, and it will specify some of the criteria that will be considered for granting adequacy decisions. The first of all, risks and benefits of the adequacy decision. Second, the impacts of the international flow of data. And third, diplomatic relations, trade, and international cooperation. It's important to highlight that here, this is a kind of proceeding that does not depend only on the companies, but specifically on the diplomatic relationship in between countries and international bodies. So it's very important that countries have a kind of multilateral or bilateral engagement in order to guarantee that each other will be considered adequate for transferring data in a massive perspective. Regarding the procedure, it may be initiated by the board of directors of the Brazilian Data Protection Authority ex officio, or upon a request from a public law entity is referred to and an information access law. So this is a kind of request or proceeding that is fully different from the others, such as the BCRs and the standard contractual clauses, because mostly it depends on the countries and the public entities to take the lead and start negotiations to recognize each other as an adequate country. Thanks again, Isabella.
Thank you, Thiago. So it's important that data processing agents follow ANPD website and communications to identify the publication of these decisions. If there is no adequacy decision to a certain country, or while no adequacy decision is issued by the Brazilian DPA, transfers can be carried out using a different set of contractual mechanisms, such as standard contractual clause, specific contractual clause, and equivalent contractual clause. Fabio, what are these clauses and how can data processing agents implement one of them or more than one of them, especially when the agent is already using a standard contractual clause from another country?
Thank you, Isabella. So yes, the new regulation actually outlines the content of standard contractual clauses. So the Brazilian authority determined that the SECCs, as we call, should be adopted as drafted. So actually no controller may change the content of the approved SEC. So this is one aspect. The controllers, exporters and importers of data that have signed data transfer agreements in the past should actually review their agreements in order to contemplate the newly approved SCCs by August 2025. So that was a year after the publication of the new regulation. So it's important for companies in Brazil and exchanging data with foreign counterparties to ensure that the contracts are reviewed in accordance with the new regulation. And there are actually some transparency requirements to be observed in the context of SECs. So, for example, the controller shall disclose the SECs on its webpage, or the SECs could actually be integrated into the privacy policy of that particular controller. So this is all viable and possible. But in any event, the data subjects may request SECs from the controller. So as I said, there's an important transparency requirement out of the use of SECs in Brazil. So in addition to the standard contractual clauses that, as I said, should be adopted as drafted without any change, There may be specific contractual clauses that a controller, for example, may request from the Brazilian authority to approve those specific clauses. But what is, I think, important to keep in mind is that anyone, could actually ask for specific contractual clauses to be approved by the authority if um, the use of standard clauses are not viable, and the regulation says due to exceptional legal or factual circumstances. So it's not sufficient to simply dislike the SECs as ANPD has regulated, but the infeasibility of actually using the SECs approved by the Brazilian authority must be proven. So it's an important aspect to be thinking about, because it's not simply because you rather have other clauses, but no, I mean, you have to prove that for some legal or factual circumstances that is unfeasible the adoption of the clauses that ANPD has determined. So another aspect is that in accordance with the new regulation, the Brazilian authority will publish the specific contractual clauses that it approves, and the entity that actually requested approval will be identified. And also there are some transparency requirements out of the use of specific contractual clauses, so data subjects may be entitled to receive copies of approved specific contractual clauses that may be used in a contract that involves a particular data subject. And the final topic that I would like to cover is that, and that was actually an interesting topic of the new regulation, that ANPD, the Brazilian authority, can actually recognize standard contractual clauses of other countries and deem those other clauses equivalent to the Brazilian SECs. So the request for recognition can be made by any interested party. So anyone can actually ask for the authority to approve or to deem a certain SECs approved by other jurisdictions as equivalent to the Brazilian SEC. So you don't have actually to wait for the authority to do this. I mean, you can prompt the authority to make that review. If you're interested to that, Brazilian authority will actually review a foreign SEC. What you need to do is that you have to make a comparative analysis between the Brazilian clauses and the foreign clauses that may have been approved in other jurisdictions, so that you have to demonstrate the compatibility between them, the two of them. So the Brazilian authority may actually open a public inquiry so that others may actually comment on whether a certain foreign SEC should be held equivalent to the Brazilian clauses. So stakeholders may comment on that decision making. But anyway, I think that was a great initiative, to relieve data processing agents from having to observe, for example, two different set of rules for the same international transfer. I think it's something new that we don't see, for example, in GDPR. So yes, with that, Isabella, I will hand it over to you for the rest of the questions.
Thank you, Fabio. And last but not least, in addition to the contractual clauses and adequacy decisions that Fabio and Thiago already mentioned, the regulation also provides for the use of binding corporate rules, which may be used to justify international data transfers between organizations within the same group. Paulo, can you comment on how the Brazilian DPA regulated the PCRs?
Sure, Isabella. And I think that the regulation brought an unexpected way of regulating this matter, as it's not a new type of document, as it already exists in other jurisdictions. So basically, what the regulation states that this process involving the adoption of PCR should contain a submission for approval of the authority. So it's a document that needs to be approved and not only being adopted, but the authority will analyze and then approve it. It needs to be associated with a privacy governance program that meets the requirements of the data protection laws in Brazil. And what I mean by this is that the group, when submitting the BCRs to the analysis of the ANPD, should not provide it isolatedly. So it needs to contemplate as well what other measures the company and the group adopts to protect the data, personal data within the transfers taking place in the group. And these BCRs need to enter into some details about the data transfer, and I will bring some of the items that the regulation established. So, for example, it needs to contain the description of the international data transfer and include categories of data, processing operations, purposes, legal basis, and types of data subjects. This is something that reveals that the authority will go into some more details on what types of data are being subject to the data transfer, and not only a general commitment to comply with the Brazilian legislation, regardless of the data that is included in this data transfer process. The BCRs need to identify the countries to which the data may be transferred, the structure of the corporate group with a list of the entities, roles in processing and contact information, the determination of the binding nature of the BCRs for all group members, including employees, the responsibilities in data processing indicating the responsible entity, an indication of the data subject's rights and means for their exercise, rules for the review process of the BCRs, and the way it's going to be submitted to ANPD for its approval. And finally, notification to the authority in case of changes to the data protection guarantees, especially if a group member is subject to laws of another country that prevent compliance with the rules set forth in Brazil. Now, the regulation does not present a specific template, so it's up to the parties to elaborate. But what is helpful in this process is that the parties, the group, can submit the decision by another data protection authority that has approved the BCRs already adopted by the group. So it's something that may be used as a reference, or at least when submitting these documents to the authority, the group will indicate that is going to keep on using the already existing binding corporate rules approved by other authorities. What is important to mention is that the ANPD also requires that the entity in Brazil is considered responsible in the group for the compliance with the LGPD requirements, and also that the BCRs need to contain provisions to answer any ANPD requests. So if the already existing BCRs adopted by the group does not contain such aspects, probably the group will need to adjust or amend these existing BCRs, even if they are already adopted in other jurisdictions. And my final comment is that this request for approval shall be submitted as soon as possible, as the regulation does not foresee any specific waiver or timeline to submit this request. So it's something that companies that are subject to LGPD and intends to cover international data transfer to its own BCRs need to comply with these requirements as soon as possible. So that's my basic comments. These are my basic comments, and Isabella, it's up to you.
Thank you, Paulo. I guess this was one of the most important and highly anticipated regulations that ANPD was expected to issue this year. This regulation is very important because it will directly impact on the data protection governance and data protection practice in companies that are based in Brazil or other companies that may participate in any other way in data protection flows and processing activities that are subject to the Brazilian data protection law. And finally, we recommend all data processing agents to continue monitoring and following the Brazilian Data Protection Authority decisions and guidance, as the Brazilian DPA is expected to issue further rules on seals, certificates, codes of conduct, and even to issue the adequacy decision that Thiago briefly explained. So I thank you, all of our audience. We hope you enjoyed the content of this podcast.